Good afternoon. I am Okada from the Faculty of Law, Aoyama Gakuin University. As the host of this symposium, I would like to thank you all for participating in this symposium, either in person at the venue or via the Zoom webinar. I have 20 minutes of your time as a commentator. As you can see on the slide, I will be speaking on the title, Significance and Challenges of the Freelance Act. I served as a member of a study group set up by the Japan Fair Trade Commission, known as the Expert Study Group, which was referred to earlier in Mr. Takeda's speech. However, this study group has already ended. Nor do I speak as a representative of the views of that study group. I specialize in economic or competition law, with a focus on anti-monopoly law, and today I will examine the Freelance Act from the perspective of that discipline and as my own personal views. I will try to proceed promptly as my time is short. I have prepared 4 slides, each of which will take about 5 minutes. I will omit parts that overlap with the content of Mr. Takeda's earlier speech, or quote from it as appropriate, as I speak. As noted on the top left-hand side of the slide, the Freelance Act was established as a minimum discipline that should be commonly applied across industries. The theme of today's symposium is ensuring fairness of trade in the entertainment and creative sectors and the role of the law, so the focus is on the entertainment and creative sectors. But needless to say, freelance workers work in a diverse range of industries. And the Freelance Act is not a law designed for the entertainment and creative sector. The Freelance Act is a minimum discipline that is commonly applied across industries and is designed as a maximum common denominator, as explained in government documents and other documents. The Freelance Act will come into force on November 1st this year. This slide contains a large amount of information. On the left side of the slide, there is a lot written in white text. This is where I wrote down what I am particularly interested in. I call this space the notes column. This slide describes the applicable relationship with other relevant laws, such as the Antimonopoly Act and the Subcontract Act, and I have written about some other points that are of concern to me. The main content is written on the right-hand side of the slide, in a larger area. As Mr. Takeda explained in his presentation, there is the Antimonopoly Act and the Subcontract Act, which stipulate what not to do, especially in terms of making transactions fair, as matters of compliance. For almost all of the acts that are stipulated here, the Freelance Act is stipulated in the same way, taking over the content of the provisions of the Subcontract Act. The text of the Freelance Act stipulates various things in more detail, but the basic features of the Freelance Act are as written in red on the slide. In explaining the Freelance Act, it would be easier to say they are the party who places the order and the party who receives the order. I will therefore use this wording. The Antimonopoly Act regulates practices where the party placing the order sets or changes the terms and conditions of the transaction to the detriment of the party receiving the order, and where this is unjustified and impermissible in light of normal commercial practice, in view of the objective of the Antimonopoly Act, which is to promote fair and free competition. Both the scope of the Antimonopoly Act and the acts that constitute violations of the Antimonopoly Act are quite wide, which is a characteristic of the Antimonopoly Act, specifically the regulation of abuse of a superior bargaining position. Among these practices of abuse of a superior bargaining position, there are, in particular, acts that are typically considered to be regulated as abusive practices, which are stipulated in Article 4 of the Subcontract Act. Article 5 of the Freelance Law is structured as a copy of the provisions of the Subcontract Act. However, as explained in Mr. Takeda's presentation, there are requirements for parent undertakings under the Subcontract Act. In the slide, the second line of the first point, just below the blue box, states, Article 4 of the Subcontract Act prohibits the ordering party, which falls under the category of a person called a parent undertaking, from committing typical abusive practices. However, in various fields, including the entertainment and creative fields, relatively small businesses that do not fulfill the requirements of such a parent undertaking have become the ordering party and are dealing with freelancers. And abusive practices are not covered by the Subcontract Act. In contrast, the newly created Freelance Act does not have such a limitation. As noted in the table on the slide, the Freelance Act applies to those who undertake a somewhat continuous outsourcing of work for a period of 1 month or more, even if they do not fall under the category of a parent undertaking, although there is such a limitation. Thus, the Freelance Act formally extends the scope of protection, which is a feature of the Act. This feature can be positively evaluated. However, even if the rules and basic principles set out in the law exist, it is not very clear that they can be applied once and for all in the workplace, i.e. where freelancers actually work, and whether the parties concerned can actually make a determination. Within the creative sector, the nature of the work and the working place varies. I would like to give you an example of an actual case in which I was consulted and referred to a lawyer. The client in question here was certainly a person who was a business commissioner or a specified business commissioner under the Freelance Act. He was also likely to be a parent undertaking under the Subcontract Act. The consultant received the outsourced work from this person after being briefed on the work to be done, which is known as the content of services under the Freelance Act. So the consultant went to the workplace. I won't mention specific names, but the place of work was a filming location for a promotional video for a very famous artist. At this point, the consultant would think that it would be enough to do the work he had been ordered to do. In reality, however, it is often not enough just to do the job. There are also freelancers working on this shoot who do a variety of different jobs, as well as employees employed by the company. Each of these people has orders regarding the nature of their work, or are given instructions as to what they are to do. However, these people work in a jumble. So, each person basically does the work that they have been ordered or directed to do, but in addition, they are asked to do this or that. Furthermore, there is the question, isn't the person who is, in effect, the one who is ordering the work, and isn't it this person who is giving the command and order? In practice, there are situations where it is difficult to understand that. Troublingly, this consultant was involved in an accident at this workplace, which left him with minor residual injuries. This then becomes a question of the working environment, which is a little off today's theme. Furthermore, questions arise as to who was commissioned to do the work in the first place, and who ordered the work that directly caused the accident. Without clarity on these issues, it is difficult to know with whom the problem should be resolved. However, this tends to be unclear. This is an example I was consulted on, but I am sure there will be many other issues that need to be addressed. On the slide, I wrote that it is complicated and bizarre. Sometimes it is unclear who on earth is a freelancer, who on earth is a business commissioner, or a specified business commissioner, whether they are workers. If you look at the reality of the way they work, these things can be unclear. In this context, the question is how to determine whether the Freelance Act applies and whether there is protection under the Freelance Act. This issue will also affect the effectiveness of the Freelance Act. I will talk about one more thing. I will talk about the second one, the main place in the main body slide. As Mr. Takeda pointed out in his presentation, from now on, all contractors will have to give what is known as an Article 3 notice. Certain matters, such as the content of services, the amount of remuneration, etc., must always be clearly indicated. However, as those who are usually interested in this matter know, and as Mr. Takeda explained in his talk, unfortunately, in the performing arts and creative fields, it is often the trade practice, or custom, or even standard, to basically not draw up written contracts. According to people from industry associations, even though it is an intercorporate transaction, and even though each project is worth 1 billion yen, they do not make a written contract. This is both frightening and surprising. They only communicate with each other by phone or line. Furthermore, it is said that the final work to be delivered and paid for is not specifically defined when the order is placed, but gradually becomes more and more concrete, until finally they say, please deliver this as the content of the benefits. The same situation seems to exist between the organization, the ordering party, and the freelancer. The lack of written communication means that there is no record to refer to later, should any problems arise. We often hear that this situation has unfortunately become standard. Once the Freelance Act comes into force, such practices will no longer be allowed. The Article 3 notice means that this will not be tolerated. This Article 3 notice is required not only for so-called companies, which are organizational clients, but also for individual freelancers who outsource work to other individual freelancers. The notice will have to be given in writing or by other means. This is a fundamental matter for the fairness of the transaction. To be able to comply with these rules, this means that workflows, a long-standing and deep-rooted problem, and trading practices have to be overhauled in a hurry. I will move on to the second point. I would like to start discussing the enforcement issues on the left-hand side of the slide. What is written here is firmly connected to the content of Mr. Takeda's speech. This is not something that was prearranged, it just happened to coincide. As has been pointed out by practitioners, including lawyers, the fact that the Freelance Act, which is a minimum level of discipline, has been passed can basically be evaluated positively. However, the question of how this will be implemented and whether the enforcement system is sufficient is also raised. There are fears that the Freelance Act will not end up being a picture-perfect law. Mr. Takeda has just given us some very reassuring words on this point. So I am sure that the government will work together to develop a solid and comprehensive system, including the development of a consultation desk. On this basis, I would like to emphasize 2 points. The first is the importance of reporting. It is necessary to make a report so that the authorities are well aware that these problems are happening in our field, in our industry. It is not enough for the authorities to say, perhaps there is something like this happening, or there are people who are saying something like this. The authorities need to get a real grasp of the fact that, in certain places, the same kind of problems are occurring in a concentrated and frequent manner. This will give the authorities the impetus to deal with the problem, even if their resources are limited. It will also facilitate the authorities in dealing with the problem. The authorities need to increase their human and financial resources. But it also needs to give a voice to the authorities from the workplace of those who do the work. Otherwise, it will be difficult to prompt appropriate measures. In other words, the parties also need to make an effort. The second point is a suggestion. It is said that the Freelance Troubles 110 helpline tends to focus on after-the-fact relief, i.e. consulting a lawyer after the actual problem has occurred. However, freelancers should above all hope not to get into problems in the first place. Problems are best avoided. It is important that there is a solid after-the-fact response, and that redress exists after something has happened. However, it is important to ensure that problems do not occur in the first place in the trade, and there should be a governmental system in place for this purpose. The slide describes it as a preventative measure. The Japan Fair Trade Commission and the Small and Medium Enterprise Agency, which are in charge of the fairness of transactions under the Freelance Act, could jointly set up a consultation desk and other public institutions where people can consult when they have problems in concluding a contract or negotiating a renewal, or where they can casually voice their concerns, such as, "I was told this by the client. Side, what should I do?" Let's look at the main part of the slide. It contains a lot of technical content, but what I want to emphasize is that it is written in blue boxes. The short answer is that the Freelance Act is not enough. In the entertainment and creative fields, the clauses highlighted in red on the slide, known as non-compete obligations, exclusive obligations, termination fee/penalty clauses, fine clauses, etc., are often found. It has been observed in not a few cases that these clauses are unilaterally imposed or amended by the ordering party on the freelancer or the party who receives the order. I won't mention specific names, but I have seen this in the case of a contract that an artist-musician with whom I was indirectly involved had with an entertainment agency. I think it is fair to say that this contract was, in reality, forced upon him. Some of these contracts included such non-compete and exclusive obligations. Overall, there are still contracts that can be seen as nothing more than slave contracts. In the midst of all this, the Freelance Act does not, unfortunately, appear to address this issue head-on. At the beginning of my slide, in the subtitle, I used the expression interpretative guidelines. Interpretative guidelines refer to the various documents published by the Japan Fair Trade Commission on its website on May 31st. The interpretation guidelines for the Freelance Act and the interpretation guidelines do not specifically address these issues. Furthermore, a public comment procedure was conducted and opinions and questions were submitted, such as, "We see many contract clauses like this regarding entertainers and entertainment," and, "How can the Freelance Act deal with this?" to which only abstract answers were given, such as, "Basically speaking." In-depth explanations such as, "It would be a violation in light of this article of the Freelance Act," or, "It could be a violation," were not given. The Freelance Act was created as a minimum discipline. This may go some way to preventing contractual problems, which are deep-rooted and have been seen as problematic, such as the issue of clarification of contracts, Article 3 notification and remuneration. However, when focusing on the entertainment and creative sectors in particular, there does not seem to be much hope that the contractual clauses that are particularly problematic here can be dealt with properly. On the other hand, and this is just my personal view, there are some areas where I think they have stepped in quite a bit. I hope that this will work well. It is the one underlined at the end of the first slide. It is about the so-called termination fee/penalty clauses. The interpretation guidelines published by the Japan Fair Trade Commission are not explicit about this. However, if you read all of the more than 200 pages of public comments and responses in PDF, you will find them, to that effect, as described in the slide, which is clarified. It would have been even more desirable if this had been stated in the interpretation guidelines. However, I think that this kind of interpretation and application and measures for cases can be hoped for, and I would like to try to have certain hopes for the operation of the Freelance Act from November 1st onwards. I will explain the third slide. It says a lot. First, look at the main section. It is lined with number symbols and may seem difficult to read. These are excerpts from the interpretation guidelines published on the website of the Japan Fair Trade Commission on May 31st, where the most important points are highlighted. In Mr. Takeda's speech earlier, he mentioned that there was a heated discussion about the handling of intellectual property and other matters in the so-called expert panel, the Freelance Act study group that was set up in the JFTC. Indeed, there was. The summary of that discussion and the main opinions are still recorded on the study group's website, which can be consulted for further details. During the discussion, there were various and conflicting opinions, including some who said that it would be better to stipulate this as a provision in the Freelance Act as a rule and make it easier to apply it in specific cases, and others who said that it would be better not to go that far. As a result, it was decided that the Freelance Act would not stipulate this, but that the interpretation guidelines published on May 31st would address concerns about the interpretation and application of the Freelance Act with regard to the handling of copyright and copyrighted works, including in the entertainment and creative fields. It remains to be seen how far this can be taken in specific cases. It may be an exaggeration to say that I am worried, but the part that I am concerned about what will happen in practice is written at the end of the first slide, in one line, in the first slide. Both the Freelance Act and the interpretative guidelines are basically based on the principle of fair trade between freelancers who are on the ordering side and the receiving side, between individual freelancers, and between the parties to the transaction, the ordering party and the receiving party, with sufficient consultation and agreement on the terms and conditions of the transaction with reasonable content. These are based on substantial consultation and agreement between the parties to the transaction. The Freelance Act lays down, further to these principles, the matters that are particularly prohibited, such as compliance with Article 5, in the Freelance Act. In other words, it is not the case that the existence of the Freelance Act means that the Japan Fair Trade Commission, etc. will regulate everything if an ordering party does something wrong. It does not mean that freelancers who receive orders will be protected to a certain extent without having to aim for full consultation and agreement between the parties concerned. The Freelance Act is a law that regulates freelancers as business entities. Therefore, the law aims to prevent disputes and facilitate solutions when problems arise, by ensuring that the parties involved in the transaction properly discuss what needs to be discussed, agree what needs to be agreed, and record it in a way that is properly recorded, such as Article 3 notice. Then, in the handling of intellectual property rights, the ordering party may unilaterally and forcefully, or irrespective with or without consent, require the freelancer who receives the order that all rights that arise in the future shall belong to the ordering party, all rights shall be transferred, all rights shall be licensed and the licensing fee shall be determined unilaterally by the ordering party, and so on. The ordering party may unilaterally decide on the terms and conditions that are favorable to it. It is not uncommon for the ordering party to say, if you cannot agree to such terms and conditions or license conditions, we will not do business with you. Even if rules and principles are clarified, the question arises as to how far substantive consultation and agreement can be expected in individual transactions when there is such an actual situation and contractual practice. Unless some measures are taken to facilitate improvements, for example, through the enforcement of the Freelance Act and clarification through guidelines, there is a risk that the rules will not be reflected in the actual situation of transactions, although I wouldn't say that they are only picture-perfect law. I would like to move your attention to the left-hand side of the slide. The issue of moral rights is highlighted in yellow. As I am sure you all know, moral rights were also an issue in the Sexy Tanaka case. A very unfortunate thing happened. However, even without going deeply into the Sexy Tanaka case, if you are familiar with the outline of the case, you will be able to understand the ideas I am describing here to a certain extent. Article 5(2)(I) of the Freelance Law sets out compliance requirements for specified order placers and specified business commissioners, but the question is whether moral rights are included in the economic interest stipulated in that provision. A simplistic view would be that they do not. Moral rights are said to be moral rights, so it seems that they do not fall into the category of property rights and economic interests. However, it is said that the reality of transactions is that a special contract of non-exercise is concluded collectively with the transfer of copyright as a property right. If this is the case, it can be said that, in light of the actual situation, a transfer of moral rights is also required in conjunction with property rights, either comprehensively or as a whole. Therefore, we believe that it is possible to interpret this as, in principle, non-exercise clauses against the will of the specific commissioned person or freelancer should not be provided based on the understanding that they are analogous to economic interests or constitute such economic interests as a whole. However, this is a practice that could cause irreparable damage to the life, health, or dignity of the parties to the transaction, rather than the fairness of the transaction. This is a pre-transactional issue. And it is the non-exercise of moral rights clause that is the cause of this, that is, the unilateral undertaking of comprehensive non-exercise, which means that the parties to the transaction have to unilaterally commit themselves to non-exercise. I think this is an issue that needs to be taken care of. As time is limited, I will go to the fourth and final one. There is the issue of intermediary providers, as typified by so-called entertainment agencies, which themselves refer to themselves as intermediary providers. It has been pointed out that it is unclear how intermediary providers are to be treated in the Freelance Act. In this regard, a government document published on May 31st and the interpretation guidelines set out the idea of determining whether a person is a substantive client or outsourcer by focusing on the matters highlighted in red. The reading and sentence structure of documents such as legal texts and interpretative guidelines can be difficult for those who are not used to reading them. To put it simply, look at the fourth line in this box. Here, the expression, where necessary, is used. It is underlined. It says, where necessary, the decision will be based on a comprehensive consideration of the following. This can be interpreted as meaning that the part after this underlined part is not to be taken into account when it is deemed not necessary. The basic determining factor is the part in red, which is the content of the commission, i.e. the services, etc., the services that are the subject of the commission, the selection of the counterparty to the transaction, the setting of the amount of remuneration, etc., how involved they are in these things, whether they are substantially involved in them. For the first time, it has become clear that it is important to consider whether or not they are involved in these matters, whether or not they are substantially involved, and whether or not they can be considered to be the ordering party. Contrast this with the left-hand side of the slide. The freelance guidelines as they originally existed indicated the factors to be taken into account in this way. With the freelance guidelines existing in the past, the Freelance Act being passed, and now this interpretative guideline being published, the idea of who exactly is an actual ordering party has become somewhat more concrete. This may be one topic for discussion during the panel discussion that follows. Here, I am only presenting my view. I have underlined it in the main part of the slide. If, in particular, they are directly responsible for specifying or carrying out the following, that is, the content of the services and the amount of remuneration, then they should be regarded as an actual ordering party, a business commissioning entity, or a specific business commissioning entity for the purpose of the Freelance Act. As for the transactions between entertainment offices and entertainers, artists, and others, if there is something like what is described in this slide, I think the Freelance Act should be able to regulate it head-on. However, as far as I have heard, there seems to be a gradual move away from management contracts, or contracts of a management nature, which are often concluded between entertainment offices and artists, towards pure intermediaries or agencies. This is only hearsay information. This is probably to eliminate the possibility of the Freelance Act being applied as much as possible. I have heard that there is a movement to change the business model or appearance so that they can say that they are only pure intermediaries and not clients, in order to avoid being regulated by the Freelance Act. Tit for tat is a poor way of putting it. However, in order to ensure that the purpose of the Freelance Act is carried through, it needs to be applied based on the actual situation. From that point of view, I think it will be necessary to make sure that this point is also supplemented. I will end with this, as it is only 20 minutes long. There are many, many other things I would like to discuss. I have also received some questions. There will be time for a panel discussion later, and I hope to deepen our understanding of the Freelance Act with you as time permits. Thank you very much for your kind attention.